reasons that the accused person pleaded not guilty, is presumed innocent. He has presented 3 sureties that this court has found substantial. This court is of the view that the accused person be granted bail, as I hereby do. The accused person is granted bail. But these are the terms. He's granted bail on the following terms. He's going to execute a cash bond of 500,000 Ugandan shillings. The accused shall execute a cash bond of 500,000 Uganda shillings. Each of the sureties presented shall execute a non-cash bond of 5 million. This is non-cash, 5 million Ugandan shillings. This matter is accordingly adjourned to 2nd of October. 2nd of October, and it shall be called at 10. 2nd of October at 10 a.m.
The accused person also is a subject to mayor. Mayor is the head. In local, we even say the mayor is the president of that division. Local people conceive it in that way. So the interest of the mayor will conflict. You can't say, let me support the accused side. About the other one, they are also yours. How will you handle it being the mayor of the division? That's the issue should be taken into consideration. In that circumstance, I pray that the mayor should be found not substantial to stand as security for an accused person. Reason being, he also owns duty for the others who are the side of the complainant. It will conflict.
Why should he be kept in jail when there is a possibility of him being found to be innocent? And indeed he pleaded not guilty.
But the discretion is supposed to be exercised decency. The court has to take into consideration when it grants bail the public interest. Whether the public interest also demands the accused person to be released on bail.
My land sister for the prosecution has submitted to the effect that there is a contradiction as regards the residence of the applicant before you. But there is a requirement under the bail guidelines. I am Nalukoola, counsel for the accused person. I appear jointly with Mr. Nsibuka Haruna, Mr. Michael Sekandi, and Mr. Suna Zakaria.
Suna Zakaria. State.
Yes, this matter has been fixed today. Purpose for bail consideration. This person is in the court. They are ready to proceed.
Let's proceed. Counsel for the applicant.
Your Worship, allow us the latitude to apply for bail for the accused person.
Please proceed.
The prosecution has proved its case. To the satisfaction of court and beyond reasonable doubt. On the basis of presumption of innocence, Your Worship, I pray that the accused person be granted bail there is a certain uncertainty as regards when the trial will commence, and in the likely event where the proceedings will end in favor of the accused person, Your Worship, in case he remains behind jail walls all that time, he will have suffered irreparable loss, Your Worship. The offenses with which the accused is charged are bailable, Your Worship. The accused Your Worship, the accused person has a fixed place of abode. That is Lusaka village, Machinde division, Kampala. He is a journalist. He is 34 years old. His phone number is 0701 87 09 59. Your Worship, we pray that you invoke your discretionary powers considering the presumption of innocence, the gravity of the offenses with which he is charged, and the fact that the accused person has never been charged with any offense, Your Worship. Your Worship, on the court record there is an introduction letter from the local council where the accused person resides. Your Worship, there are 3 sureties who are to be presented by my land friend in Sibuka Hamuna.
May it please this honorable court, Your Honor. I pray to present the first surety, Worship and Yanyama. Kasirye Nganda Byanyama, and appear for court. Your Worship, the Sureties 856, the resident of Lusaka village.
What is his name?
Kasirye Nganda Ali.
Kasirye
Nganda Ali. The worship is age 56.
56.
He's a resident of Lusaka village. Machindi 1. Machindi Urban Council Division. The accused person is an electorate and a long-time friend. The worship, he is the mayor, Machindi Division, Urban Council, where the court has the jurisdiction, Your Honor. His telephone number (0751) 62
075.
51.
Yes.
62 78 33. Your Worship, I pray to bring surety to Ntambi Moses Wilberforce. Your Worship, Ntambi is 846.
Ntambi who?
Ntambi Moses Wilberforce.
Yes.
846.
Who is it? Ntambi?
Ntambi.
Who is he? Is the one?
They are here.
Page 56.
56. Is a resident of Ndeva, in the Rubaga Division. He is a brother of the accused person. He's a businessman owning a bar at Ndeva. His telephone number.
What's the name of this bar?
Club Pentagon. His telephone number is 0772, Your Honor. 47 48
47, 48.
80, Your Honor. Your Honor, the last surety is Card Charles. The worship card is age 36.
Card who?
Card Charles.
How old?
46, Your Honor.
46. Yes.
No, 36. Pardon. 36.
36.
Your worship is a resident of Lusaka. He's a resident. His telephone number is 0752 25 00 22. Your Honor.
Come again?
0772, Your Worship. 25
25
00
yes.
22.
22. How is this card related to him?
Your Worship, he is a long-time friend
What does he do for a
and he's a
living?
businessman dealing in clothes, boutique, owns a boutique at Lusaka. Your Worship, we find that the sureties are sufficient and substantial, and we find them sufficient. And we invite this Honorable Court to invoke its discretion to find the sureties substantial.
Having in mind that the offense with which the accused person is charged with is bailable, as stated by the counsel for the accused person. And it is also noted that bail is not automatic, much as it is bailable. It is at the discretion of the court either to grant bail or deny bail. That is entirely at the discretion of the Honorable Court. But the discretion is supposed to be exercised judiciously. The court has to take into consideration when granting bail the public interest. Whether the public interest also demands the accused person be released on bail. Counsel talk about the offense with which the accused or applicant is charged with. That is bailable. Yes, it is bailable, but it is also serious in nature. And that one has been read and is known. It is a serious offense which affects actually. It can even affect the entire country. It affects the public. Much as is presumed innocent. We are not condemning that he is already guilty, but that's the fact. The counsel also cited the uncertainty as to when this matter will be tried as one of the grounds that the applicant should be granted bail. I wish to remind either the counsel that when the accused person appeared in court, we already informed the court that the inquiries are complete. This matter was not fixed for hearing, basically because we were out of time, and today it was fixed for bail application. Counsel for the accused person tried to apply for bail, but due to time, it was deferred today. That does not mean that the inquiries are incomplete. Prosecution is actually ready to proceed with this matter and have it handled expeditiously. So that one should not be a factor for the applicant to be granted bail. The counsel also stated before the Honorable Court that the applicant has a fixed place of abode. I wish to inform courts that this applicant, when he appeared before the police officer, the first thing is to establish his place of residence. And he stated that he's a resident of Chanja, that is in Nakawa division, captured in the charge sheet. And that one was his first full particulars, and also gave his one contract in regard to that. But today, counsel has come up with another contradicting information in regard to the resident of the applicant, saying that the applicant is a resident of Lusaka village. Urban Council in Makindi division, different division now from Nakawa to Makindi. That's I don't know when he shifted, but now he's in Makindi division. So also, this has not raised issue of doubt as to whether the applicant has fixed place of abode. Is in doubt created by the applicant himself or the lawyer. But the fact remains that applicant's fixed place of abode is in doubt. I pray that courts will take into consideration that when granting bail. Then the first surety for the applicant is said to be the mayor of this division. A mayor is somebody who owns duty to his subjects, being it the complainant, being it an accused person. The mayor owns duty for them as their mayor. So there is a conflict of interest. Mayor, as a surety, may fail to discharge his obligation because his interest will conflict. He has the complainant who are also his subject. The accused person also is a subject to mayor. Mayor is the head In local, we even say the mayor is the president of that division. Local people conceive it in that way. So the interest of the mayor will conflict. You can't say, let me support the accused side. How about the other one? They are also yours. How will you handle it being the mayor of the division? That's the issue should be taken into consideration. In that circumstance, I pray that the mayor should be found not substantial to stand as security for an accused person. Reason B, he also owns duty for the others who are the side of the complainant. It will conflict. Then the two sureties, you also tendered by the accused person. These are the sureties that this person introduced them, but they were just friends. They are friends. So in an event,
state.
yes.
As if the second surety is a brother, the one who owns the buying endeavor, if my record serves me well. Right?
Okay. Beg to withdraw that. But the third surety is a friend. Just a friend.
Okay.
As I've mentioned. So in an event, the accused person happened to jump court bail. He may fail to discharge his duty as a surety, which the counsel for the accused person informed the honorable court that they were being taught of their duties as a surety. But to me, he may fail to discharge his duty in being a friend. He may not be able to trace the accused person in the event the accused person runs to the village. How will he trace the accused person? He may fail, just a friend in the city. He will fail. So on that ground, also, and for the interest of justice, it's my humble prayer that this bail is denied, the matter is fixed for hearing, and is handled expeditiously, and his faith is determined. If he is found innocent, found guilty, the faith is determined. I so pray also.
Can you briefly rejoin your worship? We have not contradicted the prosecution as regards whether the inquiries are complete. What we have stated, your worship, is that we are uncertain as regards when the trial will commence. We are also uncertain as regards when this matter will be concluded. Why should he be kept in jail when there is a possibility of him being found to be innocent? And indeed he pleaded not guilty. Your Worship, my land sister for the prosecution has submitted to the effect that there is a contradiction as regards the residence of the applicant before you. But there is a requirement under the bail guidelines that every applicant should have an introduction letter as regards to his residence. The framers of those directions were aware that the prosecution normally indicate on the charge sheet the residence of the accused person. Why would it be required again for one to have an introduction letter? The accused person is at liberty to contradict the findings of the prosecution. Your Worship, on the court record, there is a letter by the local council authority confirming the residence of the accused person. And that residence is within your jurisdiction, Your Worship. Being Rusaka village in Machinde division, Kampala. Had we cited the information in the charge sheet, my sister would have objected, saying that they have not produced an introduction letter from local council authority. The information on the charge sheet, Your Worship, is a subject of scrutiny by this court. And that will come at trial, Your Worship. And that is information from the prosecution, not the accused person. Your Worship, the prosecution has as well confirmed that our client is a resident of Machinde. When she raised an objection against the mayor, Ali, being the surety, one of the sureties, saying that he will contradict his interests in regard to the complainant and the accused person, since both are his residents in Machinde division. That he owes a duty to both. Your Worship, is that a clear indication that the accused person is a resident of Machinde? As regards the mayor having a challenge of contradicting interest, Your Worship, Myland sister for the prosecution has not cited any connection between the mayor and the case before you. Is not one of the witnesses or potential witness and your worship, the accused person is still innocent. There is presumption of innocence which he enjoys. Should the mayor be judgmental at this stage that this person is likely to be found guilty at this stage? My land sister is stretching beyond the limits. I invite you to reject that objection. Lastly, your worship, my land sister for the prosecution has stated that a friend being a surety, that he may not execute the duty. That is speculative, your worship. There is no proof in that regard, your worship. He's saying he's likely, he may not, but that is speculative, your worship. And your worship, a court should not rely on such baseless objection to deny the accused person bail. Where the law does not define the relationship, which kind of relationship that must exist for one to be a substantial surety. In our practice, your worship, friends have been standing as sureties for accused persons. In that regard, your worship, I invite you to ignore and reject the objections raised by my land sister for the prosecution. Grant bail to our client on lenient conditions. Yes, we agree that a bail is not automatic, but your worship, the constitutional commandments are clear that when the needful has been done, including presenting substantial sureties, as we have done here, court may exercise its discretionary powers and grant bail. We pray that you invoke your powers as provided for under Section 76 of the Magistrate Courts Act and you grant that bail. We so pray, your worship.
The arguments made for and against this application. The accused person is charged with 2 bailable offences. He denied the charges, is presumed innocent until he voluntarily pleads guilty to the charges or until he is found guilty by a court of competent jurisdiction. It is this presumption of innocence that gives the accused person a right to apply for bail, but like it has been stated by the state attorney, and it is the position of the law that to grant or deny of this bail is at the discretion of the court, which discretion court must exercise judiciously, that is to say fairly and reasonably. The state objections relate the fixed place of abode for the accused person. The argument is that the accused person informed police officers that he is a resident of Chanja, which is in Nakawa division, and the introduction letter that he has presented through his lawyers today shows that he is a resident of Lusaka, marking a division. Argument is that these are 2 totally different divisions. She also objects the first surety for reasons that is a mayor who would be in a conflict of interest because he leads both the complainant and the accused, the person. The other objection relates to the third surety being a mere friend, that he may not be in position to execute the duties of the sureties. I have considered the arguments made in rejoinder. The first of all, the requirement of the accused person presenting an introduction letter from the area guidelines. I want to argue with counsel for the applicant that the framers of these guidelines knew that that information can be found in the charge sheet, but they put this as a requirement. Since the accused person has presented an introduction letter that has not been withdrawn by the author, this court shall take information therein to be the authentic and the place of abode for the second objection. Here, I do not see any conflict of interest by this witness, this surety. The other one relates to the third surety being a mere friend. I do not know, whereas the ideal should be people who are closely related to the applicant, but in circumstances where a person is presented much as is just a friend, courts have found those people to be substantial sureties. The sureties are found substantial. All the 3 sureties presented are found substantial in this matter. For reasons that the accused person pleaded not guilty, is presumed innocent, he has presented 3 sureties that this court has found substantial. This court is of the view that the accused person be granted bail, as I hereby do. The accused person is granted bail. But these are the terms. He's granted bail on the following terms. He's going to execute a cash bond of 500,000 Ugandan shillings. The accused shall execute a cash bond of 500,000 Uganda shillings. Each of the sureties presented shall execute a non-cash bond of 5 million. This is non-cash, 5 million Ugandan shillings. This matter is accordingly adjourned to 2nd of October, 2nd of October, and it shall be called at 10. 2nd of October at 10 a.m.
Much obliged, Yours.
Thank you.